It's a table to. You ready?
We are.
Okay. Okay. This is tabled appeal from an earlier meeting, and it is for Jonathan and Tammy Osborne. No, wrong one. Oh, okay. Sorry. Let me start over. That's next. Okay, so we have the 720 Development Corp. And the town of Topeka. Okay, now we're in the right one.
All right.
So let us begin by swearing in the witnesses. So will all persons who may be witness in this hearing, please raise your right hand to be sworn in?
I'm the attorney. I'm not testifying. I'm happy to.
Okay. Do you solemnly swear or affirm that all the testimony you're about to give is the truth, whole truth, nothing but the truth?
I do.
All right, thank you. So then let's begin our testimony by, shall we have the taxpayer begin first with what they want to present? Okay, would you please
We
present?
probably need to read in the parcel number into the record since it's,
Yes, so we can, so this is a Form 136 application for property exemption on parcel 44-113-0-300-001-101-006. And I have the, I don't have the address here.
probably does not have.
325 Nature Trail, Topeka. It shows on the
Okay.
script here. Okay.
Okay.
And that is the correct place. Okay, just double checking.
All
Okay.
right. I think those formalities are done.
Okay.
Make sure it's right.
Thank you.
So would you like to explain what this is all about?
Yes, sure. Thank you. We appreciate your time this morning. This request pertains to what is currently a 28.47 acre parcel of undeveloped land in the town of Topeka. The property was formerly owned by the Topeka Redevelopment Commission that wanted to undertake a housing development project to attract new workforce housing to the community. The project was conceived as a result of a market potential study conducted by Zimmerman Volk. Initially, a private developer was brought in to help construct the project, but when that private developer was not able to make the deal work financially, the town engaged our client, Club 720 Development Corporation, 501c3 nonprofit corporation, to assist with the project and make it a reality. And with that, I'd like to introduce my witness and maybe ask him some questions.
Okay, please do.
Could you please state your name for the record, please?
Sure, I'm Ryan Chasey. I am the Chief Operating Officer for the Club 720 Development
Mhm.
Corporation.
Mr. Chasey, can you describe what your roles are as Chief Operating Officer for Club 720?
And so in my particular role, I work directly with communities that we are engaged with, specifically on helping them to understand what their housing market potential is, and then find opportunities to be able to develop to that potential in ways that the private sector can't and won't do. And so those efforts focus primarily in smaller communities where it is more difficult to prove out that market.
Okay, very good. Can you just describe in general what Club 720's mission as an entity is and some of the types of work that it undertakes?
So we have a mission to cultivate thriving communities, and our work really entails what I just kind of led into, which is working with communities to use kind of a national firm and methodology to measure what their housing market potential is. So that shows them the number of units, the type of units, and the cost of those units that of people that want to live in that community. Once they have that, then it's oftentimes taking the next step to understand how they can go about supporting the development of that, because we will very rarely find that just having that data is enough for a private sector developer to come in and take the risk. It's often, we have to assist those communities with the next steps, which can look like, taking ownership of a property and installing infrastructure on a property and actually getting it to the point of being constructible for new units.
Okay. And were you involved in a market potential study here in LaGrange County?
Yes.
Okay. That. Here, I hand you a copy of this. Is one copy enough for the two of you? or-
Yeah,
Okay,
that's
thank
fine.
you very much.
Thank you very much.
Mr. Tracy, I just handed you what I hand wrote at the top of the document as Exhibit 1, and I wanted to see if you could just generally identify what this document is for us.
Yeah, this is the summary presentation of the market potential analysis that was conducted. This was led by the LaGrange County Economic Development Corporation with engagement from each of the towns here in LaGrange County, the town of Topeka, the town of LaGrange, the town of Shipshewana all took part in this, as well as other stakeholders.
And were you involved in either soliciting or analyzing data and reviewing this report?
Yes.
Are you familiar, you've seen this summary report before, correct?
Mhm.
And is what I provided you a true and accurate copy of the summary report that was prepared?
Yes.
Okay. I don't know if you have any formal admission procedures for evidence, but
No, we really don't.
Okay. very good. Well, I'd just like for the record to offer this as Exhibit 1.
Okay. We'll accept that. Thank you.
So Ryan, you mentioned that this is kind of the first step that counties or communities will take a look at what their potential is, and it could be countywide, it could be community by community. What was the result of this report as it pertains to the town of Topeka?
So the result of this, and you can see on this cover slide here, I mean, this is kind of the ultimate summary, is there's significant market potential within LaGrange County of 325 to 475 new housing units spread across the county. And so, deeper into this, there are slides that have, optimum market position for the town of Topeka, annual capture market potential specifically broken out for the town of Topeka. And so that became then somewhat of a roadmap for their community leaders. They had property that they had previously purchased before this was done that they had hoped that housing would be developed on, but this provided a roadmap for them.
Okay, so who acts upon this? Is it the communities themselves, or is this distributed to private developers, or is it in conjunction, with the communities and developers, or what? How does this get put into action?
So this is a public document. After this was developed and released, the EDC released it publicly. I think there was a news release that went out. There was an event that was held around that for interested stakeholders. And so it's available. Anybody can take action on it. I mean, this is on our website to this day, that developers can use this information, go out, buy property and develop to that. As I mentioned in my earlier comments, that's often not the case due to risk. And so we see then communities who have a vested financial interest in seeing these units develop as well, taking action in order to be able to develop those units. And so that looks like towns, cities, RDCs, counties in some cases that are then actually moving into what do we need to do to build to our market potential.
Okay. Can you describe, with respect to this parcel in the town of Topeka specifically, how were you brought in to assist with that project, and what has your role been in connection with that project?
So as this plan was being created, Stuart Bender, the town manager, was a part of that, and attended the meetings about this. He approached us as this document was being released and said, the town RDC owns property that it had previously purchased to be developed, and said that they had been unable to get a private developer to be able to take that project and move that forward. And so he asked then if that was a project that we might be willing to consider an engagement with the community to help move this from, property, just vacant property, farm property, into a development. So that's how we came to be part of that.
Why didn't the town just do the project on their own?
They did not have the capacity to be able to do that. And so, that was why they went the route. They actually solicited a public request for proposal from developers. And from that was previous to my engagement, but from what I understood, struggled to get very many responses. They did get some responses, and then those who responded ultimately were not able to deliver on that. So, I was told that if we were not able to help with that, then, the alternative was to, eventually look at having to sell this back into farm ground because the town didn't have the capacity to be able to develop it on their own.
And when you say capacity, are you talking about like the staffing resources needed to oversee a project like this, the ability to take on risk? What all involved is involved in that?
Staffing is one. The risk tolerance is certainly a second portion. I mean, that RDC in particular does not feel that that's, the proper role for, for government to go to that level of risk to take on a full development. And so, entering into the partnership with us was something that was appealing to them for that reason.
Does Club 720, do you act as a developer in like a private capacity where you'll go around and acquire properties on your own and seek to develop them on your own?
No, we don't. We would only develop where a community would bring us in, and where we would have an engagement and agreement with that community to be able to undertake a development.
So the work you do, at least in this realm, is strictly in conjunction with a public, whether it's a town or a county.
We are not developers. I do not look for or respond to developer RFPs. We don't do work other than in communities that are undertaking, their market potential analysis and then trying to take action on it. It's all specifically within, it's called the home method, which is the kind of the method that we follow where we work, where it's based on this kind of data.
Can you just talk a little bit about what activities or work on this project Club 720 specifically has done?
Yeah, so our work, we have overseen the engineering for the site. We have then overseen the bidding and the procurement of the contractors to be able, which included a significant amount of site excavation, as well as then installation of the utilities infrastructure, including water, sewer, streets, and then completing that engineering work with subdividing that into lots that can be sold.
What is your relationship? Do you report to the town of Topeka? Do you keep them informed? Do you answer to them? What is the relationship with the town of Topeka as this project progresses?
I work extremely closely with the town of Topeka, so I work with their town manager, Stuart Bender. I mean, he is informed of almost any significant decision that is being made, and he oftentimes provides input into that to make sure that we're carrying that out in a way that is in accordance with their goals for what they ultimately want to see here with the development. I go to their redevelopment commission meetings each month, to keep them apprised of progress. They are directing, of me in terms of, things that they are aware of or have heard. And, we have that regular back and forth. So I mean, on a more than monthly basis, I'm in contact with the town, either town manager or clerk treasurer, and then the redevelopment commission every month. And so that's our opportunity for, them as again, the ones that have had the vision and have looked to partner with us to carry this out, to make sure that it is in accordance with what they're doing. So even something is detailed as like the neighborhood covenants. The town attorney is reviewing, we provide a draft and they are reviewing and marking those up in accordance with what they want to see in their vision for this. Even though in a typical scenario, that would be something that would, go right to the plan commission and they would not, have that level of input on that. But because they're really the ones directing that, this is all provided to them ahead of any formal submission.
Would you be doing this project or involved in this project if not for the Topeka Redevelopment Commission?
No.
And in your opinion, would they be doing this project if not for you being willing to step up and assume the role that wasn't being filled by the private development community?
No, they had, I think I mentioned earlier, their attempt to engage a private developer, but they had owned the property for 2 years, 2 full years by the time we were engaged. So they had made a substantial effort to try to go that route.
What's the end objective? Obviously, we're talking about a housing development, but what kinds of units? What is the targeted audience? I mean, who are the buyers that you're trying to appeal to?
The town's focus on this has been workforce housing. So the reason they're engaged is because they, are a town with a population of about 1,000 residents that during the day when people are working there grows to about 5,000 people. And so they know that of those people that are commuting in, a number of them would live within the town if there was housing that was available. And so obviously there's a significant economic benefit to the community in having, that tax base as well as just having that increase in population base for things in the community. And so focusing on the workforce specifically, a 60 to 120% area median income is kind of the band that we've targeted, with the town for that. That is something that will hit their workforce and really serve their employers.
As the project progresses, I think you kind of mentioned that you've overseen the engineering, the plat work. Eventually, will there be infrastructure installed? Or has there been infrastructure installed at this point?
The infrastructure is substantially installed at this point. So it's, we're close to completing here. I think just a few kind of punch list items. The paving is in, the sewer and water is in. And so it's, the infrastructure program is almost complete.
And did you have a role in overseeing or managing that infrastructure package?
Yes, I was the primary person from our team, our Cleveland County Development Corporation team that managed that. We actually, as part of the risk associated with this, and we took on a contracted project manager to do site inspections, to work directly with the vendors. I oversaw her and that, and then that was, what I coordinated all of her technical work with Stewart and the town.
And that was somebody that you engaged, that you paid for to help oversee the project.
Correct. Yeah. So it's, we're as a nonprofit. I mean, we have a board of directors, and that's one of the things in these projects that they understand the risk that goes along with that and have to sign off on before we go under contract with any of these communities, that this is a risk that the organization's willing to take.
What is the timeline for completion, do you estimate?
We are planning on probably either very late yet this year by the end of December or very early next year having the final plat that will be presented to the Plan Commission. So infrastructure being obviously completed at that point, and have that final plat adopted at that point.
And then what happens? Do you identify builders to sell lots to? Do you have specific partners you target, or what?
So we have created with the community, we call it a joint development committee. And so it is the town manager and a representative from their town council, as well as me, that are the 3 parties that are on there. And so we are working to determine how are we going to engage builders? We have input now on the covenants because obviously that factors into what that's going to look like. But it is, that group is town controlled, two members on there. And so we're working to make sure then that this is, built in a way that meets their goals for it, and the builders that are involved and all those sorts of things are what they envision.
If the town came to you at any stage of the project and said, whether it's the covenants or whether it's, the layout of the development, and they wanted changes, is that something that they would have the authority to direct you to do? Is that something that just as a partner you would do? Or do you have full latitude to just develop this project however you see fit?
Well, no, we have to work with them. We have an agreement in place with them. And so there are mechanisms in there where they have, levels of control. We don't have, we have a level of control as well, obviously, on things that are in the best interest of or would be detrimental to our organization, but we do not have autonomy on this.
Is there anything else you'd like to share about this project or your role in the project, your relationship with the town of Topeka or otherwise?
It is a unique model, and I recognize that. That was part of the conversations we've had with the town is, understanding this because we're doing this and this model exists because the traditional ways of doing things are not resulting in development. I think that the town has shared that it's been many, many years, I will say, since there's been significant development there in terms of like a neighborhood. And so this is something historically that they have felt like they need to pursue a different avenue.
That's all the questions I have for Mr. Tracy at this time.
Okay, thank you.
Thank you. My name is Zach Price. I'm an attorney representing the county assessor. I just have a few questions for you, if I could, Mr. Tracy. Okay, so you mentioned that the sort of the target market for this housing is going to be individuals between 60 and 120% of the area median income. These properties wouldn't actually be rent restricted or income restricted, would they?
They would not.
Okay. So there was discussion about how Club 720 doesn't go out and seek development projects on their own. I guess once this entity has been engaged by a municipality for its services, how does that relationship then differ from how it would be with a private developer at that point?
Oh,
Go ahead.
there is the relationship that we have. I would say it's a night and day difference from what the relationship with a private developer would be. We are, as I mentioned before, really working at the direction of that community. And so the relationship with a private developer would be specifically tied to financing primarily is what we see. Our relationship goes well beyond the financing in all the ways that I just shared. This is from working closely with the town on all the aspects of the planning. So the plan for that neighborhood in particular, I should mention, was created with the town. The town led that. So we didn't come to them with a proposal, with a layout, with the number of units, with the type of units. That was based on this document. And then we brought in an architect that the town redevelopment commission and other members met with that gave their vision. And that's how this whole site concept was created. And so that's not, in my experience, how a private developer would work on that.
Okay. In the packet that was submitted with the application here, there's a part 2 which says exempt purpose. There's a list of, looks like employees and board members there. Are those all of the employees of the company currently? Let me take a look at mine.
I make sure we got the same one. like the same.
Your question is, are these all the?
Yeah, the current employees of the company and the board members.
It is all the board members, it's not all the employees.
Okay. How many individuals are employed by Club 720?
Seven,
Okay. Does that include the board members or exclusive of the board members?
exclusive of the board members.
Okay. And these are paid employees, right? Not volunteers?
Correct.
Okay. And it looks like the total payroll expenses for 2024 were about 489,000. Was that just spread amongst the 7 employees that you mentioned?
Yeah,
Okay. Okay, I noticed a couple different entities with a similar name to Club 720. Those are, I think, Club 720 Mortgage LLC and Club 720 Solutions LLC. Are those entities affiliated with the Development Corporation?
they are, those are privately held companies that are not directly affiliated with the organization. They're owned by Heather Presley Cowan, who's the president and CEO of the nonprofit.
Okay. They're solely owned by her?
Yeah.
Okay. Do those entities have any role in the Development Corporation's operations, I guess, here in LaGrange County?
From a business, like a business operations, or from a delivery standpoint of?
I guess would Club 720 Solutions LLC be engaged by a town as part of your development operations, or would the Club 720 Mortgage LLC be involved in, getting mortgages for the people that are going to live at the development or anything like that? And I apologize if I'm not phrasing that eloquently.
So the Development Corporation has a licensing arrangement with the Club 720 Solutions.
Okay.
And that is based because there is a Club 720 platform. It's an app that individuals can use to find things like down payment assistance, coaching, to be able to get into homes. And so as we talk about constructing these homes, we're focusing heavily on, obviously, the development and the infrastructure here. But the town, and certainly we as want to make sure this development is successful, and that those folks who are working for the employers actually have the resources they need to get into those homes. And so we license that software, and then that is software that's there's a countywide down payment assistance program called Hoosier Homes that the EDC is rolled out. And so people have access to that by going to that app.
Okay. Okay, and that's for the Club 720 Solutions LLC?
Correct.
And then would the Mortgage LLC be involved in any way in arranging mortgages for the individuals, or is it just a totally separate?
We do not currently have any role in that.
Okay, all right, thank you.
With the mortgage company specifically.
Okay, I don't think I have any other questions for Mr. Chasey.
Okay.
All right.
Joe, do you have something?
Just a couple. Let me see if I can run through my scratches I have here. And on this community project, how long did the town of Topeka try to do this on their own before they contacted you?
My understanding is that they had owned the property for about 2 years,
Okay.
and that they had, according to Stuart, had their eye on it for significantly longer than that.
All right. And the town of Topeka contacted your organization. You did not go out and solicit this project.
Correct. We, through this countywide work, and as this was developed, Stuart approached us and told us about this property that they had, and invited us to come and meet with the RDC.
Okay. Covenants or restrictions on the properties. Is this going to be a homeowners association or is it not?
Yes.
Okay, so it will be a home HOA.
Mhm.
Will there be restrictions on lifestyles within the community? We are a very unique situation with LaGrange with our Amish English demographics.
Mhm.
Are there restrictions on this property that would exclude an Amish family from moving into one of these homes?
No.
As
well,
far as their lifestyle, where I'm basically going,
Yeah.
will they be allowed to have a horse on this property?
We can supply a set of the covenants. I don't recall any restrictions offhand that would, disqualify certain types of lifestyles, but I'd prefer to supply a
Sure.
set so you could actually.
And
see the-
this is an off the cuff question, and
Yeah.
I respect your answer. I have always been a little leery of public-private partnerships because I can see where there's a lot of areas, there's a lot of shades of gray that could be developed within a private-public situation. So I do want to look out not only for our English citizens within the community, but also our Amish citizens within the community to make sure that what the town is moving forward with and what you are moving forward with is good and equal for all.
Sure. And that is part of the reason why it was important to involve the town's attorney
Mhm.
in the review of those to make sure that they met the community's needs in a way that Topeka thought was appropriate. But we'd be happy to share the draft, and they haven't been finalized.
Okay.
So
The study that was done on the demographics of those working within Topeka, do you know if there was a breakdown done on that between the English employees and the Amish employees? Or were they lumped together as a total number of?
No, they were, I don't know, there are tables of data that back up the information. This is the summary
Mhm.
presentation. And your question is essentially, were the Amish included in this or counted
In the
this?
total population count of the employees, or the total count of the employees working within the Topeka area,
Oh,
there's a percentage of those that are more of the more rural Amish
yeah.
lifestyle and
Yeah.
those of the English or the non-Amish. Just was asking if those numbers might have been skewed in one way or another, or whether they exempted the Amish from the total population or the employee data.
I believe that the data behind this actually broke that out at some level so we could, fully understand what that looked like because of the uniqueness of that situation and not either overestimate or underestimate based on that being included. So I believe in the tables that support this, that was broken out. I don't know if, the number I had cited that the town cites about going from 1,000 to 5,000 during the day. I'm not sure if that includes Amish.
That was the number that I'd heard, and that's why I was wondering what percentage of those were potential people moving into these homes versus generally most of the Amish employees live out in the rural area and either bike in or have a driver bring them in.
Yeah, no, that's a good question. That's something I would have to ask the town if they, where that came from. That was not really part of this. That was their number that they cited. This study actually gives the overall market potential, and it breaks it down, by where those people are coming from. So we could see that in this information.
All right. Funding to your organization. Are you basically footing the bill for all of the infrastructure and everything put in to date?
We have, as a nonprofit, we have to access to some different types of funding than for-profits would, and so we've utilized that. That's part of what is spelled out in our agreement with the community. There is is really the cash flow and how reimbursement works on these. So yeah, ultimately the responsibility is on us to pay for this.
Are there any county dollars being invested into this project from the county's level?
County level, no.
Okay. The reason I was asking that question was because of in the Indiana Constitution, there is an exemption where you cannot have county dollars put into a incorporated activities. So that's why I just wanted to make sure that there is a separation there.
Mhm. Yeah. I mean, yeah, the agreement that we have with, with the town really has to do with, flow of funds and
Okay.
timeline and so forth. There's not a contribution that they're making. Actually, they're being paid back for the purchase price of the property as these lots sell.
Okay. All right. What is the anticipated selling price of a lot? Or are you going to be selling the lot in the house as a package?
That is what we're evaluating right now with that joint development committee, is if we're going to package those or if we're going to sell lots.
Will it be a one or the other or a combination?
It could be either.
Okay.
That's what we're deciding right now. I mean, and that's really based on, making sure that it's accessible for the intended targets, financially accessible, but also that it is fully developed out.
Okay.
And so we're looking at how we can make that work.
And how many total lots are you, or projects?
The first phase, there's 77 lots.
Mm-hmm.
Then they're probably not big enough for Amish if there's 77 lots in the first phase.
I would say probably not. Okay. So, okay.
That's it?
Questions? Do you have questions?
I do have a couple. You just asked the one I was going to ask first, the number of houses and the size, lot size. But has there been any provisions for the downturn in the economy? We know that the RV industry, which is what Topeka thrives on, is volatile. And right now it's not rising. It is in a spiral downturn. What kind of provisions, or if this goes belly up, what are we going to do?
Well, yes, there have been provisions made for that. I mean, we're fully understanding as we assess the risk, which is what you're speaking to.
Mhm.
That's part of our evaluation organizationally about this. Is,
Okay.
the risk level that goes into that. And so part of how we're working to mitigate that risk, I referenced an answer, how we use the Club 720 platform to directly reach buyers and make sure that they, have access. We are working at the same time as we, come in and get these homes constructed to make sure that we do outreach and engagement to reach folks that are wanting to live in there and understand what their financial barriers may be. And so part of our mission is not just to go in and do developments, but also just like we've bridged the development gap on this development to make that happen, understanding, what are tools that individuals might need to be able to get into these homes. And some of them it's coaching. And so as a part of our nonprofit mission, that's what we do. We coach folks on the app, to help them improve their credit, do things like that. But we also then can look at, different products that may be available nationally that aren't available here yet, like down payment assistance, like other things. We work with local, institutions like banks to make sure that all their products are, available as much as they want them to be on that platform. And so part of how we mitigate that risk is that we're not just constructing it and hoping. We're at the same time as we're doing the constructing, going out and working to actively build that pipeline of folks that want to buy in there. And I mean, there's still risk that's involved in it, but that's a way that we're trying to mitigate.
You know, these homes that you're going to be building, are they restricted to like stick built? Are they going to be modulars? Or is it just going to be a double wide community? Or is there any stipulation on what kind of housing goes in there?
The expectation is it would have to meet zoning requirements, but stick-built, single-family residents are.
Because we've all seen double wide communities come and they don't usually fare real well in the long terms.
Mhm.
Okay. I guess that's pretty much all I have. Anything further?
Sure, yeah, I've just got, I'll be fairly brief, but before I start, I just want to say that nothing I'm about to get into, I don't mean to state that Club 720 Development is, their services are not well-intentioned or benevolent. Seems to be very helpful to municipalities and they fill a particular role there. So while I'm arguing against the exemption, I'm not trying to argue they're not a well-intentioned company, but the current legal standards for receiving a charitable exemption are that the property has to be owned, occupied, and used for an exempt purpose. And the Indiana Tax Court in 2020 in a case explained the current standard for evaluating a charitable purpose. So that a charitable purpose generally will be found to exist when a taxpayer provides probative evidence to the Indiana board showing, one, a relief of human want manifested by obviously charitable acts different from the everyday purposes and activities of man in general, and two, that a benefit sufficient to justify the loss of tax revenue inures to the public through these acts. So first of all, just going through the requirements there, property development is not a traditional charitable act. There is no obvious relief of human want that is directly connected to the taxpayer's actions here. There may be a municipal need for a service, but there's not a direct fulfillment of a human want by Club 720 Development. They're not directly providing low-income housing to taxpayers. Next, it's certainly not an obviously charitable act. It's not a soup kitchen. It's not a homeless shelter. You can't look at what they're doing and say this is obviously charitable. It requires quite a bit of evaluation. Third, there's no way to gauge whether whatever benefit is being conferred is sufficient to justify the loss of tax income. Any benefit to the public is far too speculative and removed from the current use of the property to justify the loss of tax income. And just a few other points here. They are a 501c3 nonprofit, but that's a very different standard than a property tax exemption. Require different standards. The nonprofit status is given to an entity, not to a property. So we're not evaluating the entity, just the property use here. This is not an entity that's staffed or run by employees. There are 7 employees. They appear to be relatively well compensated at about $490,000 in payroll spread around there. The fact that they're filling a niche role in helping a community is not necessarily a charitable act, excuse me. That's a business model. There is a provision in the Indiana Code 6-1.1-10-16 that provides that a taxpayer who purchases a property with the intent to develop it into an exempt use can receive an exemption before the construction is finished, but there's no indication that the final use of this property will be charitable. It appears to just be for ordinary housing. And finally, not that anything nefarious is going on. There's just the presence of this affiliated entity, the Club 720 Solutions LLC, that appears to contract with the Development Corporation and has common ownership, but itself is not a nonprofit. It's not bound by any nonprofit requirements there. So that's just another sort of unknown, I guess, at this point. So based on the foregoing there, my recommendation and request for the board would be to deny the charitable exemption at this point.
May I respond to that, please?
Yes, please.
We appreciate the feedback. And we agree that this is a somewhat unique scenario, but I think the way that the charitable use has been construed as not consistent with the broad application that the IRS has provided for, and quite frankly, Indiana case law has addressed. The term charitable, IRS has described 3 different ways that term can be met. So it's one, relief of the poor, distressed, or the underprivileged. Two, lessening the burdens of government. And three, combating community deterioration. A charitable purpose will generally be found if there is evidence of a relief of human want, as discussed, and there's an expectation that a benefit will inure to the general public. The state of Indiana has undertaken the burden to create housing opportunities for low and middle income families under IC 520-1-1. The legislature has declared that it is the policy of the state that there's a need for residential housing to satisfy this particular set of individuals. The definition for low income is up to 80% of the mean AGI. Here, as Mr. Chasey's described, the targeted individuals range from anywhere 60% on the low end to 120, so squarely within that low to middle income targeted population. College Corner LP, a case before the most recent tax opinion that was cited here, specifically addressed this concept of addressing a human want. And that's a case that involved redevelopment of a historic community down in the Indianapolis area. And they specifically addressed this argument that while it's true that a redevelopment project doesn't address or relieve a human want as traditionally considered, that's not the only way to satisfy that burden. Things like relieving the government of the burden to expend resources that it would otherwise have to expend to enable that government to allocate those resources toward other purposes is a way that the relief of human want can be satisfied. So while we understand that this is maybe not the traditional sense of what you think of with a soup kitchen or a charity, there's no doubt that the town of Topeka has received a benefit from the work that Mr. Chasey and Club 720 have provided by not having to expend those resources to make this project a reality. As Mr. Chasey mentioned, they had owned this property for 2 years and they were unable to develop it during that 2-year period of time. Had they not brought in Club 720, this project wouldn't happen. There will be new infrastructure installed. Once these units are constructed, there will be new assessed value generated for the benefit of the community. So in that sense, there really has been a lessening of the burden on government, which clearly qualifies as a charitable purpose under the IRS's framework. So again, we acknowledge that when you think of charity, this doesn't necessarily neatly fall into the box, but based on the IRS framework that has been provided, the case law construing what is required to meet that burden, we feel like this project and this particular project or this particular property falls within those parameters.
Well, do you have anything else, Joe?
I'm
Okay.
I'm pondering for a
Okay, you're
moment.
pondering. Okay, we'll allow some pondering time.
The property that's under development right now is officially owned by the town of Topeka. Is that correct? Or is it not? Okay, it is owned by this organization. So the town of Topeka did own that property prior and they transferred ownership of the deed to your organization.
Yes.
I just want to make sure that I have everything correct in my mind.
Here, I got one VQ here. The town of Topeka had it. And then they transferred it to this.
Okay. So is the town of Topeka currently reimbursing your organization for any expenses?
They're not reimbursing us. They are, in some cases, cash flowing, and then we are reimbursing them.
Okay. So they are playing the role of a lending institution or a bank on some of the infrastructure.
So,
Okay. Well, I want it to be noted that I am a simple-minded, uneducated person. But by reading Article 10 of the Indiana Constitution, under Section 6, it does give me some concern. Section 6 is, no county shall subscribe for stock in any incorporated company unless the same is paid at the time of such subscription, nor shall any county loan its credit to any incorporated company, nor borrow money for the purpose of taking stock in any such company, nor shall the General Assembly ever, on behalf of the state, assume the debt of the county, city, town, or township, nor any corporation whatsoever. The meanings and the wording of when they ratified that on February 18th of 1873 they had no idea of this type of situation would exist. However, I am concerned with the fact that the town of Topeka has been extending financial resources to you, even though you have an agreement. They are playing the role of the bank on some of the project. Based upon my concern as an uneducated man, I think I'm going to make a motion to deny the request for tax exemption.
I will second that. We have a motion and a second to deny the request for the 730 club,
720.
720, sorry, 720 tax exemption. Is there any further discussion?
No. I would like to make a comment before the final vote. Both sides have argued this very well and made an excellent presentation.
Thank you. All in favor of denying the motions or defying the, oh, I'm sorry. I've had a very rough week. Please bear with me. All those in favor of denying the tax exemption signify by saying aye.
Aye.
Aye. Opposed. Motion carries. I
This is an administrative hearing being held on November 19, 2025 in the LaGrange County Annex Building. This hearing is being recorded. This hearing is being conducted pursuant to the laws of the state of Indiana as found in IC 6-1.1-1-1. The proceeding number is 44-01025-0-5-00018. The parcel number is 44-10-32-200-060.011-010. The property address is 7215 South 175 East, Wolcottville, Indiana, 46565. The assessment year under appeal is 2025. Does everyone present agree with the year under appeal is as stated?
Yes.
The only issue is you gave the wrong zip code.
Yeah, I think that's what I heard too.
46795.
Pretty
There we are.
You are right, 46795, as far as Wolcottville, Indiana.
Mhm.
My name is Kim Fairchild, and I'm Secretary of PTABOA.
The following other persons are here representing the PTABOA,
Joe Billman.
and I'm Deborah Notstein. The following person is representing the taxpayer. Would you please state your name for the record?
Kim Fairchild from the Assessor's Office. Nope,
Oh, did I go
Sorry.
too far?
I jumped ahead,
Yeah.
sorry.
I'm the taxpayer. Would you please state your name for the record?
I'm not a taxpayer, but my name is Tammy Osborne.
The following persons are here representing the county assessor's office.
Kim Fairchild,
Zach Price, counsel for the assessor.
And would you please state your name?
And my name is Ben Bentrup, representing the LaGrange County Commissioners.
Well, all persons who are may be witness in this hearing, please raise your right hand to be sworn in. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
yes.
Tammy?
Yeah, yes.
So since we're doing a phone hearing here, you can go ahead and give us what information you want us to have. Then the county will.
Madam Chairman, one quick question
yes.
before we get started. Is it okay if we address you by your first name as Tammy, or do you want it as Mrs. Osborne, or how would you like me to address you?
Yeah, Tammy is fine.
Okay, that's fine. I am Joe. I appreciate that. Thank you.
So
No problem.
after that, you have given us your information, the county, and will give us theirs, and then we will discuss and make a decision after that. So please proceed. Tammy.
Okay, so I'm proceeding. Okay, well, actually, I'll just start off giving a summary as to why I'm here. And I'll let Zach take the reins because we're here as a result of the meeting that we had on May 20th. So I'm asserting that office is acting outside of their lawful authority. I'm asserting a jurisdictional violation, which would be a deprivation of rights under color of law. And I have yet, as a result of the May 20th meeting, I presented a case, and none of the information I presented was rebutted. It was just given a denial, just a blanket, we disagree, and then we moved on to this hearing. So I can certainly, I guess, maybe start with the constitutional limitations, the statutory limitations, but I guess at this point I would like Zach to present the evidence that I am within the jurisdiction of the state and the county, and I can rebut accordingly. I haven't been given any evidence that I'm under the jurisdiction of the state, so.
Respectfully, Ms. Osborne, the burden falls squarely on the shoulders of the taxpayer when they're making a constitutional challenge against property taxes, which would require the challenger to go first. So I've got a case for this. It's included in my packet. It's the 6th item I had in there. This is Solani versus Lake County Assessor. This was a property tax appeal that made it all the way to the Supreme Court and dealt with the assessment of homesteads. The Supreme Court clearly noted that the party challenging the constitutionality of a statute bears the burden of proof, and all doubts are resolved against that party. So I don't think the burden's on the county to present the evidence first in this situation. I think we need to hear the challenger's evidence. I think that's the way this works.
Right. I think the error here is that I'm not making a constitutional challenge. The statutes are constitutional perfectly. I'm making a jurisdictional claim that you're acting outside of your lawful authority. So I'm wanting evidence that I am within the jurisdiction of the state. So I think maybe I think the county is assuming because my property is located within the exterior boundaries of the territory of Indiana, that puts me in the jurisdiction of the state. So I think that, and I'm looking at the evidence that you gave me. All these court cases are like, constitutional kind of claims, but and I said in my hearing that I'm not debating the constitutionality of the statute. It's perfectly constitutional. I'm just saying you're acting outside of your limitations.
Okay. Tammy, this is Joe, one of the PTABOA members. So just for my own clarification, so I have things correct in my head, you are recognizing the United States Constitution as a founding document?
Yeah.
What about the Indiana Constitution, state constitution?
Yeah.
Okay, so you recognize both of those as the founding and supporting documents for that all of our other laws and guidelines should be based upon?
Yeah.
Okay, thank you. I want to make sure that you were comfortable recognizing both of those founding documents.
Yes, and actually, I guess that's a good segue into I can go into why I think that you're acting outside of the limits, because none of the information provided from Zach really, it could be rebutted very quickly. So your limitations, so you guys are working under statutory authority. Okay, statutes have to be constitutional. So I'll kind of walk through this framework here,
Okay,
just to
please
kind of set the stage for why you're acting outside of the jurisdiction of the statutory limitations. So it's a jurisdictional violation. So in the Indiana Constitution, Article 4, Section 27 is a jurisdiction. That goes over what the General Assembly has the authority, what kind of legislation they have the authority to pass. Okay. So it says, every statute shall be a public law, unless otherwise indicated in the statute. That's the rest of the statement. So then you have to ask yourself, what is public law? Well, so I went to my Black's Law Dictionary. I used the 6th edition. And public law is the portion of law that defines rights and duties with either the operation of government or the relationship between government and individuals, associations, and corporations. Okay. Mm-hmm. So basically from this statement, we've got, okay, well, public law is the operation of government, so government employees. And then the second part is individuals, associations, and corporations. So I'm like, okay, that's interesting. So I guess when you first read it, you think, well, I'm an individual, so that must be me. But when you look at the rules of statutory construction, and that would be, so the canon of construction would be nocitur associates, is what a word is known by the company it keeps. Or you can use adjustum generis, which is general terms, follow specific ones, and are limited to the same kind. So associations and corporations are entities. So the individual must be an entity. Okay. Mm-hmm. So that just tells you that the legislature, the General Assembly, has the authority to regulate government and entities, legal entities created under the authority of the state. Mm-hmm. And then another thing that kind of supports that, another article that supports that is Article 11, Section 13. It talks about corporations other than banking shall not be created by special act, but may be formed under general law. Okay, so that just tells me that corporations are creatures of the state. Okay, so that's confirmation.
I'm just reading along with you in my copy of the Indiana Constitution.
Mm-hmm. Okay, now Well, we can go back to Article 10 later, but because I think, even when I've reached out to the DLGF, they kind of cite Article 10 as their authority to tax everybody in the state, right? So if I'm going to jump to the Indiana Code next, because there's a jurisdiction statement in the code, okay, and it's under the hierarchy of law, and it's Indiana Code 1-1-2.5-1. And it says, this chapter applies to all goods grown, manufactured, or made and services performed in Indiana.
Mhm.
Okay, so that's a jurisdiction that's constitutional. So the General Assembly has authority to regulate creatures of the state. Okay, so those are legal entities. Okay, so fine, that's constitutional. And then you get down to Indiana Code 6-1.1-2-1, and it says, except as otherwise provided by law, all tangible property which is within the jurisdiction of the state on the assessment date of the year is subject to assessment and taxation for that year. So if you don't understand anything, you're like, well, okay, my property is located in Indiana, I'm taxable. However, it's got to be within the jurisdiction of the state. And the state only has the entities, okay, and government employees. But in this case, so this would relate to entities doing business in the state of Indiana,
Mhm.
who is growing, manufacturing, or making something or performing some sort of business inside of Indiana. And then there's Supreme Court cases that support this. So like, I guess I use this one. It's Miller Brothers Company versus Maryland, 347 U.S. 340, 1954. And the holding of this case is the court said a state's jurisdiction to tax requires the power to enforce the tax, which is your authority, minimum contact, or presence. So presence would be the location, and the minimum contact would be a nexus. So like doing business of a creature of the state, some sort of, business registration or something. There's got to be something there to give you a minimum contact. And then let's see. So where else can we go from here? Honestly, I only need those few things. So it's not a constitutional. I'm not challenging the constitutionality of the statutes. The statutes are perfectly fine.
Mhm.
They're just and this is obviously not you guys. When I understand that you are not doing anything willfully. So you're not doing anything criminal. It's just everybody's just doing what they're told, and then nobody's asserting their rights. Or if they do assert their rights, they don't know how to do it, and they make a terrible case,
Mhm.
and they lose. And then the lawyers hold it up and saying, "See, this person did this." Like the Osborne case in the court. It was a terribly argued case. They lost it, and now everybody waives that case as evidence that everybody's property is taxable. But the problem is because we don't know how to assert our rights, we just go along and pay the bills that we get in the mail.
Do you have any?
And there's nothing. I
This
have
is,
researched. Go ahead.
this is Deb Notstein. Do you have any other evidence that you'd like to present that says that you are not required to pay taxes? And these court
Well,
cases and stuff are fine, but
Mhm.
they're not really relevant for what we're doing here today.
Well, what would you like me to present as evidence?
Well, whatever
Well,
you
do you have a-
need, whatever you need to prove that,
Deb, if I may ask a couple of questions.
yes, you may.
Yeah.
Tammy, do
Yeah.
you, I want you to, for full disclosure, I'm going to be picking up my coffee mug and showing it around the room, and it is a "Do Not Tread on Me" coffee mug. So
Mhm.
I follow the general line of thought that you're going. I want it to be known that I despise the idea of property taxes. If there were any way of getting out of it, I would do it in a heartbeat. I have researched
Like,
on my own as an individual, as an uneducated individual, the claims of the land patents exempting property taxes. I have gone through and looked at a lot of different questions or different things. In my personal research, I have not found a strong enough argument to get either you nor I out of paying property tax for the common good. Going through historical documents, going back to the time of the founders, I feel that they were extremely in-depth in their thinking and their ability to foresee where they were at and into the future. And I think they did one heck of a good job in laying out our founding documents. But going back and doing some research, even the founders required a need for taxation for the common good. Would you agree with that, that there is a need for taxation for the common good?
I do, but you're limited on who you can tax. I mean, corporate, you can, so taxes can be assessed on corporations, and those taxes are supposed to be for the common good. But you can't infringe upon the private rights of the people. The government is the creature of the people. We created government. The government created corporations. Okay, so that which one creates, one controls.
Okay.
So the thing is we have allowed this to infringe upon our private rights. Okay, you can tax businesses to whatever extent you want. I mean, eventually they'll fold if you tax them too much. But what I'm saying is, you don't have the authority to tax private property. I can't really say that. Private non-operating property. So our home, our private shelter. Now there are homestead deductions, which somebody who is running a business out of their home, I guess maybe we can use that, they can get a deduction, or somebody who is living, if they're they own an apartment complex and they live in one of the apartments, they get a homestead deduction. Okay, why do they get a homestead deduction? Because that's their private home. They're allowed a certain amount of money for that, but they're doing business on that property. So the misconception is that the government has the authority to tax private homes, not engaged in any commercial activity. So the Indiana Constitution gives the government authority to regulate interstate commerce, and that is carried through into the statute.
And you'd be referring to Article 10 of the Constitution?
Who said, go ahead.
You'd be referring to Article 10 within the Indiana Constitution?
Well, that's perfectly constitutional, but then you have to understand what you're reading. So somebody who said you can't just throw around court cases as evidence. Well, I'm being given court cases as evidence. You've got the authority over me. Do you have a contract? Do I have a business registration? What evidence do you have that I'm doing business? You can drive by my property. You can even pull up a picture on Beacon, and you can see that it's a small cottage on a small parcel for private use.
Why do you think that, I guess I don't understand the business end of it all. You keep saying business.
Right.
I don't understand how that plays into this.
Because that's the only property you can tax lawfully.
Well, you get a homestead credit for a home that you're living in. You don't have to be doing any type of business to get a homestead credit.
Well,
you have to be living
the problem. So we all think that, we're going to do a homestead deduction and that's, that's all that we're entitled to. But the problem is I'm not even a party to the homestead.
That's because you don't live in this home.
Yeah, I live in a home that's there for shelter.
Is this your
Why would I
primary
even-
residence?
I'm sorry?
Is this your primary residence where if you were going to vote, if you were going to register to vote, is this the address that you would put on that registration to vote?
No,
Okay, so this would not be considered your primary residence. Do you have
it
another
doesn't,
dwelling
doesn't-
somewhere else that you also reside?
yeah.
Okay,
Yeah, it's, I live. I've got two homes and they're of private nature.
okay.
I can own as many homes as I want.
Well, you most certainly can.
On them, right? So this is the thing. I think when you guys read, and this is, I mean, obviously not your fault. So we're trained at, when we read something, we don't understand what we're reading. And so, like I said, I'm giving you I'm reading directly from our Indiana Constitution and statute. And you're still, well, what is your evidence? Well, good Lord, what do I need? So it's very hard to and I get it because you're in the business of this is what you do, right? So the thing is, it's like, then you have to ask yourself, if somebody doesn't pay their property taxes, okay, in the home that they spent all their life paying for, their shelter, and they don't pay their property taxes, you guys can go in there and seize that property and sell it and take it away from them. Under what authority can you do that? I mean, look at the Bill of Rights. Look at the rest of the Constitution. Then look at the statute. I have spent a couple of years or more trying to find where it says that you could do that, and I can't find it. You have to understand the definition of taxpayer. You've got to understand the definition of person. You have to understand the definition of residential. That's a business property.
I guess,
And we don't have,
if your whole argument is you don't want to pay taxes, that's your argument, correct? You don't want to pay taxes. Is that correct?
What is not lawfully owed, no,
Okay.
of course not.
So let's have a scenario where your house catches on fire.
Yeah.
What are we going to do about that? We have no taxes funding any fire departments. So what are we going to do about your house catching on fire?
Guess what? I'm going to call the fire department.
There is no fire department because you paid no taxes to support a fire department. So who do you call?
Because you know who's supposed to support that fire department is the taxes on business.
Well,
and we would be just fine, but our government gets involved in so many things that they shouldn't be involved. Waste, fraud, and abuse.
There is so many businesses around your house here to pay the taxes to fund the fire department that I just really don't see how you would have a fire department.
Well, and I would like to just make a comment here. This is Joe. As the former fire chief that covers your home, I am well aware of the cost involved with running a fire department as a public entity. I'm well aware of the funding that we use from property taxes. The majority of our funding to buy the new $1 million fire truck when we need one comes from the citizens and their homes. Yes, I agree with you, Tammy, that in an ideal world, all of the taxes that we need for a limited republic government, not Republican, but a limited republic, would be able to come from business. However, with the size and scope and the population that we have today compared to the time of the founders, that is an unrealistic goal, is to be able to have everything funded just by taxes and tariffs upon business. If you go back and if we take a moment and if I can, I did a little research into this. And if we go back through the history of the founding of our country, prior to our fight with England for our independence, there was taxation that they needed. Coming through after the Revolutionary War, there was a need for taxation. In fact, Congress on May 20th of 1785 declared that any of the 13 states, former colonies, that had any lands west and north of the Ohio River to the Mississippi River to the shores of Lake Superior, they turned those lands over for the funding of the war debt from the Revolutionary War. That right there says that there was a need for public monies to fund the public good. If I move to further documents, Dr. Benjamin Rush, he had a public letter that was posted in, I believe it was one of the Philadelphia newspapers in 1806, going over the plan for the establishment of public schools. I will not go through the entire document, but reading through that document, it says that there is a need for taxes to cover common good, just like with the fire department. We can move further a few years later to after we went from Articles of Confederation to the Constitution. Alexander Hamilton, in his first report on public credit given to Congress, goes into the need for limited taxation for the public good. Moving further, another name from one of our early founders, Patrick Henry, on December 23rd, 1790, drafted a response titled "The Resolution on the Assumption of State Debts," indicating as an anti-federalist, being the equivalent of a states' rights person, that there still is a need for public fund or private funding of the public debt. So historically, I cannot find any place, and I have looked, to support that because you own a piece of residential property,
I don't own residential
that you don't
property.
have to
Very
pay
meaning.
taxes.
Okay. Well, I think in most of what you said, there is a need for taxation, but you're very limited in scope. So you mentioned the school system,
Mhm.
and the Indiana Constitution, Article 8, Section 2, says taxes on the property of corporations that may be assessed by the General Assembly for common school purposes.
Mhm.
Okay. That doesn't say that you can tax men and women. So when somebody said something about the fire department burning down and not having enough business, well, there's agricultural land. So if you're farming, then unfortunately you're subject to taxation because you're engaged in interstate commerce.
And
Okay.
I do pay a lot of taxes on my farm ground, but I don't pay enough to support a fire department.
Mhm.
There was no way a
Well-
farm could ever support a fire department by taxation. You can hardly pay the bills you have now. So that's a marvelous argument, but it's not gonna pay the bills.
Well, the problem is you're making the argument because we can't pay the bills for a fire department that I am. That's not really an argument either. I'm giving you constitutional limitations and statutory limitations, and what you're doing is giving me feelings and
You're giving me a lot of I thinks and I thoughts. So I guess,
Tammy, what is your ultimate goal with this hearing? To have the
number
county
one-
wipe your tax bill completely out? Is that your ultimate goal?
yeah, the assessment on my property needs to be void. It never should have happened anyway in the first place. And of course, I didn't know. so I didn't assert my right.
Mhm.
Okay.
Let me ask another question, if I may. When you acquired the real property that the home is setting on, did you purchase that outright with cash? Did you have to take a mortgage on it?
Yes, I purchased it with a mortgage.
Okay. So
Is that relevant? Is that relevant?
it actually is, because if you went out and this is my uneducated opinion on, and from my research, that if you went out and you purchased that real property using Federal Reserve notes, you have a contract between two individuals on that piece of real property. If you have established a mortgage or a agreement with some form of lending institution to advance you those Federal Reserve notes to pay for that real property, then that becomes a legal and binding contract. Would you agree?
With two private parties?
If you went and if you arrange for a mortgage with either a bank or other financial lending institution, is that loan or mortgage an agreement?
Between, yes,
You
me,
said between
the,
yourself and the bank.
yes, that would be correct.
And you are bound by the terms of that agreement as far as repaying interest?
Yes.
Also, within that loan agreement, I am sure that there is a clause stating that any and all assessed property taxes upon that property shall be paid.
If it was subject to it, sure.
So by signing that mortgage agreement with whoever your lending institution is, that means that you have agreed to the terms of that mortgage agreement. And if that taxable clause is in that mortgage agreement that the taxes shall be paid, then you have agreed to pay property taxes.
No, it just means if I owe taxes, I should pay them. So that way they're not in hock for it. So if you look at the sales disclosure, which is probably evidence to my benefit,
Mm-hmm.
there are 4 types of property. So I am limited to, there were 4 options on there for whoever really filled out this form. There are 4 options for properties, and that's residential, commercial, agricultural, and industrial.
Mm-hmm.
Okay, so 3 of those we know for sure are legal entities. And the debate is, everybody says they've got residential property, but I don't have dwelling units on my property. I'm not a dwelling house. Like I'm not an owner providing dwelling to anybody.
Mm-hmm.
I don't have residential property.
Mm-hmm.
That's a business property. Okay, and there's no check mark here for private property. I can still get a mortgage on private non-operating property. Businesses get loans to or mortgages from their business property, and if they're subject to taxes, they pay them.
Mm-hmm.
They have to, according to their agreement.
Are you required to
But
keep?
that's not evidence of taxability, is what you're trying to do.
Tammy, sorry to interrupt you.
Right.
Part of your mortgage agreement or your loan with the lending institution, did they require that you have property insurance on your home? So in case a tornado or a fire or other natural disaster were to hit that property, that they would be reimbursed.
Well, I'm sure to protect my interest and their interest.
Okay. So that also comes back to the bank is saying that you must pay the county's assessed value, whether you agree with it or not. By signing that mortgage document, you have bound that real property to the terms of that agreement.
Is it within the jurisdiction of the state? Again, you keep going to this other, and I don't have my mortgage agreement here, but I'm assuming it probably says if you owe, and maybe they just assume that.
Well,
Maybe
I
banks
know
should
I
be-
have borrowed money within my lifetime, and every time I've had any type of loan against real property, those were in the fine print at the bottom that nobody ever reads.
So what are you saying? By me signing a mortgage, that puts me under the jurisdiction of the state to pay taxes on private non-operating property, is
That
what you're
is-
asserting.
Unfortunately, that is what I am saying.
Okay. Well, just so you know.
That is my interpretation of Indiana law from what I have read, the US Constitution, and personal
There's
life
there's not-
experiences.
No, there's nothing in the Constitution that asserts what you're just saying. Now, if you have that law, I would like to see that. I would like to read it because I have no idea what law you're referring to.
I would say you just need to go back and look at you need to go look at your mortgage agreement, and in there you should find that property taxes shall be paid at the assessed value.
Okay, but what if my assessed
If
value
you
is
have
zero?
that mortgage agreement and it does not have that clause, then you may have grounds for a further discussion. But as of right now, I think our hands are pretty well tied because you
No,
have
they're
a
really not.
mortgage upon
What
that
if the
property.
value is zero? What if my assessed value is zero? I don't have to pay anything. You're the one that assesses it. You've got the duty of care there.
Mhm.
So I'm telling you, I'm giving you pretty significant amount of evidence here.
Mhm. And I do appreciate the evidence that you are presenting.
Okay, so I'm not sure, and then I'm going to give you another, not that this matters at this point, because you guys had your mind made up probably before you started. So, and I don't have to continue on with any. I mean, I might entertain it for sure, but I don't legally have to or lawfully have to continue an administrative hearing because number one, you're assuming that I'm a legal entity that is subject to administrative hearings. Okay, I'm not. I'm one of the people. And that you're acting outside of your jurisdiction, and I don't have to continue. I can go straight. I can take it straight to court, really. So it depends on how long I'm willing to entertain this.
Tammy, you are an individual. I am an individual. Every human in this room are individuals. However,
right. You're an individual in the common usage because we refer to each other in common language as individuals. But legal terms have different meanings in the legal world.
I'm well
you
aware.
have to understand the differences. And that was very hard for me to get. It really was. At first, I'm like, what in the heck? I can't comprehend this. It took me quite some time, actually. So, and here is, and just to close this out, because obviously we're probably not going to get anywhere here, but there's a case, Redfield versus Fisher. It's an Oregon Supreme Court case that explained that corporations are artificial entities created by the state and can be taxed for the privilege of existing under state law. In contrast, individuals in the common meaning have natural rights, and I know this is a common meaning because it says natural rights after it. They have natural rights to live and own property, and those rights cannot be taxed as a mere privilege. Okay, there's court cases out there that you can find that, and the older ones a lot of times are better.
Well, I would agree with that also. What is that court case?
It is Redfield versus Fisher, 1930, Oregon Supreme Court.
Redfield. Say 1930.
So I think is we're stuck in this, mindset of do what we're told, do what we're used to. Everybody's educated in this public school system, and then we go to work and we're so busy, we just do. We think that the government has authority over us in our private capacity. And this is why we're in the situation that we're in the world today, because we don't know who we are. We don't know how to read and understand. And they've done a fair job of really making it difficult for the average person to understand.
Tammy, I want to ask the county if they have any more information or evidence they would like to present at this time.
I'd like to ask Ms. Osborne a couple questions if I could.
Mm-hmm.
Ms. Osborne, this is Zach Price. Nice to talk to you again.
Yes.
You're asserting that this is not a constitutional challenge. So I'm just trying to clarify what it is exactly. Are you contending that the actions of the county assessor are constitutional in assessing your property?
She's acting, well, I'm going to say, technically it wouldn't be, but it's a jurisdictional violation. So she's acting outside of her authority, which is a breach of duty. So could I, yes, I could bring a deprivation of rights under color of law claim, but I'm giving everybody the opportunity to correct this before I need to do this. But I'm not going to stop fighting because you guys said, no, I don't agree with you. Well, then, all that historical information is just fine, but the Constitution just doesn't allow for it, and neither do the statutes.
Another question, Ms. Osborne. In the packet that I sent out, there is a case called Bartholomew County Assessor versus Housing Partnerships. It's the 5th case in there, and I'm looking at page 3. There, the tax court is looking at the statute that you cited. It's Indiana Code 6-1.1-2-1. It's the one that states that all property in the jurisdiction of the state on an assessment date is subject to taxation. In the Bartholomew County Assessor versus Housing Partnerships case, the tax court interprets that statute to mean, quote, all tangible property in Indiana is subject to taxation. Just that reveals, the plain language of that statute is that the jurisdictional requirement is simply a reference to geography. All real property in Indiana's border is subject to taxation. Do you contend that the tax court's application and interpretation of that statute is constitutional?
Wait, hang on. Just 1 second. So you're saying jurisdiction is just location?
Yes. In this context, yes. In the context of property taxes.
I don't know why. So number one, that's not the complete statement of the statute. If you look at 6-1.1-2, that they're missing within the jurisdiction of Indiana in there. And the other thing is let's see. Nonetheless, Indiana's constitutional rights of the General Assembly may. Okay. So then let's get back to then Article 10, which is what everybody loves to quote when they talk about property taxation. And let's see, I just have some notes here. Article 10 relates, okay. Okay. So basically Article 10, I should actually just flip to the actual and get to it quickly. Maybe.
Tammy, this is Joe. I have my Constitution, so I want to read along where you're at.
Yeah, okay, just let me find Article 10. Okay. There's a couple clues. Well, number one, okay, so if you read Article 4, Section 27, and you understand the limitations of what the legislature can, like the laws that they have the authority to create, okay, then when you read this, it says, subject to this section, the General Assembly shall. Okay, well, there's clue number one, because the General Assembly can't regulate private rights, okay? They've got government, the operations of government, the employees, and creatures of the state. Okay, so there's clue number one. And then you go down and you read all this mumbo jumbo, and then you get down to where it says F. This subsection applies to property taxes first due and payable. The General Assembly shall, by law, limit a taxpayer's property tax. And then it gives a whole bunch of other crap that we tend to get into the minutia. But then who are taxpayers? Taxpayers are entities under the authority of the state, which is constitutional. But you're applying and this is the thing. So you're applying it to the private rights of men and women to their shelters. Okay, you can't do that. And the funny thing is like we give exemptions to charitable organizations for providing basic human needs. So they get an exemption. So they're a business, but they get an exemption for doing that. But then we turn around and we tax the shelter of men and women. Doesn't make sense. And then you can take that away if they don't pay. That
May I
doesn't
get
make
back to my
sense.
question?
Yes,
respectfully?
please. We're
So-
going way off track here.
Ms.
So
Osborne, the current judicial interpretation of Indiana Code 6-1.1-2-1 is that all tangible property in Indiana is subject to taxation. Do you believe that definition and interpretation of that statute runs afoul of the Constitution?
Well, if you're assuming that the judge was saying that, then that would be definitely a foul of the Constitution.
I mean,
because
I'm quoting the
there-
case right here. As a general rule, all tangible property in Indiana is subject to taxation. And they cite Indiana Code 6-1.1-2-1. That was written by the judge in this case, so.
Okay, well, I guess then now I have to question, what is the general rule? So there are Supreme Court cases that say that it must be located inside the territory of Indiana. Then it must fall under the authority of the state government.
If I could clarify, the general rule is,
Popular belief, the government does not have authority over the private rights of men and women. If they did, it would infringe upon the Bill of Rights. Okay?
the general rule is explained by the following sentence, which says, nonetheless, Indiana's Constitution provides that the General Assembly may exempt property from taxation if it is used for educational, literary, scientific, religious, or charitable purposes. That is the only exception to the general rule noted by the court here.
Right, but that would have to be, you'd have to already be under the authority of the General Assembly. So if you're under the authority of the General Assembly, so the state, so if you're already under the authority of the state, then they can exempt if they want to. Okay?
That was the only question
But
I
I'm
had. Do you mind if I proceed with my presentation?
Please do.
And I'll try
Sure.
to keep it quickly. I know we've been here a while, but I know Ms. Osborne has presented this as not a constitutional challenge. I believe that a court would interpret it as such. It seems that the argument is that either the statutes that authorize property taxation and assessment or the actions of the municipal government and the assessor and the auditor are afoul of the Constitution. That is my interpretation. I don't know how else to take this argument. And I guess with that being said, I just wanted to quickly address how the Indiana Constitution actually references property taxes, not clues that are in there, but the plain language in the Constitution. So Article 10, Section 1, the General Assembly shall provide by law for a uniform and equal rate of property taxation and shall prescribe regulations to secure a just valuation for taxation of, quote, all property, both real and personal. The next section lists that the General Assembly is permitted to exempt certain property types from taxation. There are certain types laid out there, shelter or non-operating residence is not listed in the list of exemptions there. Next page, subsection F provides for tax caps for the types of property, includes 1% on homesteads, 2% on other residential property. There's no indication that the General Assembly indicated for that term residential property to include an operating business. There's just no indication it's intended to refer to anything other than a place where somebody lives.
I believe number 4, with the fact that they've put the cap on businesses at 3%, means that the General Assembly was trying to look out for the individual taxpayer to the best of their ability by taxing businesses at a potentially higher rate than the individual. That's my interpretation of reading the code.
Sure. And so based on my understanding, I think the way a court would interpret this as a constitutional challenge, first thing I have to put out there is that administrative bodies such as this one, unfortunately, don't even have the power to rule on constitutional challenges.
That is true.
It's, Article 3 of the Constitution says no branch of the government may infringe on the purposes of any other branch of the government. Article 7 specifically assigns judicial powers to the court. The Indiana Board of Tax Review readily acknowledges this. They never rule on constitutional issues. You can see that in the Restoration Institute case that I provided. It's the third item where the IBTR clearly states that administrative agencies do not have the power to declare a statute unconstitutional. So with that being said, I don't believe Ms. Osborne can get the relief that she's seeking from this board.
No, statute is not unconstitutional. This is not a constitutional challenge. I'm not arguing that. You're just acting outside of your authority.
Is this a valuation
So
challenge to the value of your property, Ms. Osborne?
I'm sorry, say that again.
This board is empowered to deal with valuation issues and applications for property tax exemptions as outlined in the Constitution. I don't see that your claims fall under either of those.
So you're saying that, okay, so you're saying that you don't have the authority to void an assessment for overreach.
The board, an administrative agency such as the PTABOA or the IBTR is not empowered to overturn any agency action, any statutes, any regulations on the basis they don't comply with the Constitution.
Okay, Zach, I mean, you're a smart guy, but I don't want any statute overturned. They're perfectly fine.
So the statute that provides that as a general rule, all tangible property in Indiana is subject to taxation. That's the tax court's current interpretation of the property tax statute. You don't believe that definition should be overturned?
No, within the jurisdiction of the state, it's missing. But the reason why it's missing is because the plaintiff, I believe in this case, was an entity.
That it's just a general statement of law by the tax court.
Columbus, Indiana. So they were already dealing with an entity.
The tax court states it as a general rule, not specific to this case, not specific to this entity. So I'll move on now. I mean, I'll address the merits of it. I'm not asking the board just to.
Well, tangible property in Indiana, I would have to be subject to taxation. Not all property in the boundaries of that you can't do that. The Supreme Court says you can't.
Doesn't it say all tangible property?
All tangible property, yes.
And isn't tangible meaning something you can buy and sell? Is that
Anything you can touch, real or personal.
Okay,
Yes.
so
But you have
Something
to be,
real.
If this is
you
a
have
t-
to be in the jurisdiction of the state.
And that's a
I have-
geographical
I
reference.
have to be the government to tax me. I would have to be a creature of the government. Okay. So
Well-
this is why our country is off the rails, and this is
No,
why a
we're
lot
not,
of
hey,
states.
I have a comment here, and I'm coming just right in the middle of everybody's presentation, and we're going to finish up our presentations here pretty soon. But according to what Zach has stated, that this board cannot change or recognize you as non-taxable because that is not our authority. Am I correct?
Yes, absolutely.
So we
It-
can
it-
argue,
no.
we can argue till supper time. And we still will not
Yeah.
have the authority to change
I think
this situation.
So that would be a breach of duty then. So yeah, it sounds like I probably am kind of wasting my time. So you do have a duty and you can do it. I presented the information to you.
We do not have the
think-
authority. So would you like to finish your,
I would like to quickly address the substance
Okay,
of the arguments,
please.
okay, if I could. Next point I want to make is that the burden is squarely on the taxpayer here. The case number 4, which I mentioned earlier, the Solani case, it's recent from this year. Indiana Supreme Court states that the party challenging the constitutionality of a statute bears the burden of proof. All doubts are resolved against that party. I know Ms. Osborne asserts that it's not a constitutional challenge, but I believe that it is, and I believe it be recognized as such by the court. And to that end, I don't believe what we've heard today, these breadcrumbs and these clues that were being found in the Constitution or this Oregon case dealing with the rights of individuals, and we don't even know what the Oregon Constitution states. I don't believe we've seen anything convincing here today that would show that Ms. Osborne's property is not subject to taxation. There's been no proof provided that residential dwellings are used for, must involve a commercial enterprise or something like that. There's no proof that that was the intent of the Constitution. No evidence that a private non-operating home that is only used for shelter is not within the state's jurisdiction for property taxation purposes.
But what evidence do you have that it is?
The burden is
I'm
on
giving
you,
you-
Ms. Osborne.
Oh, okay. I see.
In addition to all of the evidence I have provided. One final case, Ms. Osborne mentioned this one. This is Osborne versus LaPorte County Assessor. This is the tax court case from last year. This is the 6th case I provided here. These are, not the same challenges, certainly, but similar challenges. Mr. Osborne argued that the imposition of annual property taxes violated his inalienable rights, violated his rights to due process. The Board of Tax Review, as the tax court noted, rejected his claims on the basis it could not rule on constitutional issues. And looking at the 6th page of this case, Court said, having exercised this power, the General Assembly determined that all tangible property which is within the jurisdiction of the state subject to assessment on that year. Consequently, all property in Indiana must be assessed and taxed annually on January 1st. And another quote from that case, this tax court states, merely reciting quotes from the United States Constitution, the founders, and foundational documents is not enough to show that the taxpayer is not subject to property taxation. So to conclude, I would just reiterate this body is empowered to deal with property tax issues, valuation and exemptions, not challenges of the sort being presented today. Even if it were, the burden of proof lies on the taxpayer. There has been nowhere close to enough evidence presented that supports the claim that the taxpayer is outside the jurisdiction of the state for property tax purposes. And I would ask the PTABOA to deny the taxpayer's claim.
Tammy, I have a question for you. I'm looking on the county website, Beacon. It appears that you acquired that property or the home in question and the real estate under it. It's dated June 21st of 2022. Is that on or about the correct date?
Probably, yeah. I mean,
And
I'm sure.
and listed here in the public records is a sale price of $185,000 in Federal Reserve note valuation. Is that correct?
Why do you say that? Why do you say that?
Say what?
Why do you say Federal Reserve note valuation?
Because that
You
would
said that
be,
a couple of times.
that a Federal Reserve note is the equivalent of the US dollar. If you actually look on a US dollar, it says Federal Reserve note, not US Treasury. So,
Okay, what's the
which doesn't mean the US dollar. So you paid $185,000 for the property, according to the public
Well,
record.
okay, and
So is that a legitimate question? And are you verifying that that is how much you paid for the property?
what are you getting at?
I'm just asking how much you paid for that property. The reason
Okay,
the reason why I'm asking is I'm verifying to see whether the county's appraisal is too high upon that property, trying to look out
What-
for
right,
all
what
of the
gives-
taxpayers within the county.
So what gives, and this is the whole question, what gives you authority to tax my private shelter? You guys don't have it.
It's
You're
not
asserting
your
I'm making
private
a
shelter, ma'am.
constitutional
It is your extra house. You live elsewhere. So that would put it in another category altogether.
You can, if you want to go back and look at Indiana code, it's not exactly correct, but if you take, I believe it's 36.115.3 subsection D, commonly known as Indiana log cabin rule, that which allows people to make improvements upon their own primary residence, basic improvements. That, using that same understanding, as a secondary residence, you do not have that same ability under the Indiana log cabin rule to work on things. So there is an understanding of a difference between primary residences and secondary properties. So what I'm wanting to do is look at the county's assessed value on the property in question to see if they have overassessed. If they have overassessed, this board has the ability to make small modifications. That's why I was asking if you paid $185,000 for the property.
I did.
Okay. And looking at the public records on Beacon, the current assessment from the assessor's office is, I believe, $187,300. So there is a difference of $7,300 in the assessed value since you paid $185. So, or excuse me, so there's $2,300 difference.
And why do I care about any of this? like seriously, I'm here telling you you shouldn't even be assessing. You don't even have the authority to assess my property.
Well, that is not something that we as a board can pick and choose who is assessed and who is not. Our hands are bound by what the General Assembly of Indiana has created
Right.
for rules, whether we agree with them or not. Our hands are tied on this matter.
All right, but the General Assembly didn't give you the authority to do it. So you're just making, because it's common practice, that it's lawful. Okay, this is why all these states are coming out now. Oh, we're gonna propose a bill to eliminate property taxes, and then they're some savior, because they realize that, I mean, taxation on corporations and you know, agricultural, commercial, all those things, that's fine. They lawfully can do that. But they can't touch private non-operating property. They
Do
can't
you
touch
have
the
any
homes of
further
men and women.
evidence
And
that you can
if-
present to support
Yes,
that position?
I'm sorry, say that again?
Do you have any further evidence to support that position? You've given us
The
what you
Indiana
have. Do you have any more? Legal evidence, not thoughts, feels, something like that. Legal evidence.
I'm not giving you thoughts and feelings. I'm getting thoughts and feelings from you guys. I'm giving you
Okay.
articles from the
Okay.
Indiana Constitution
Tammy,
and statutes.
this is
statute.
Joe. I understand your viewpoint. I respect the thought and in-depth analysis that you have given to this situation. I must say that as a individual, I can agree with a few of your points,
He has a question.
but I can't follow 100% with where you're going.
Okay, and so just so, I mean, because you're like, whoever said that we can argue till dinner,
Okay,
it sounds like that's
yes.
probably what we could do.
All right.
But at this point, the only evidence that you guys are using is what Zach gave me for these court cases here. And the fact that I have a mortgage
Mhm.
and that jurisdiction is, if I'm within the territory of Indiana, I am subject no matter what,
Mhm.
because that's the assumption.
The abilities of the PTABOA board are limited by state statute. What we can and cannot do, whether I have my personal feelings in it or not, I have to go by the written rules.
Okay, and then did everybody here like swear an oath to the Indiana Constitution? Well, I guess it doesn't matter because you're bound by it no matter what, because you're a public servant.
We as
Right.
PTABOA members are required to take an oath at the beginning of our term.
Okay, I just want to make sure.
Mhm.
And
All right.
Tammy,
think
we
so. I
have
think-
one more question here.
Tammy, this is Ben Bishop again on behalf of the LaGrange County Commissioners, and I have a couple of questions. I'm trying to understand your position, so these are only for clarification purposes. Is it
Yes.
part of your position that with respect to this property, the state of Indiana does not have the sovereign ability to tax the property?
Yes, that's correct.
Okay. Second, referring to the Article 10, Section 1 of the Indiana Constitution, is it part of your position that the state of Indiana does not have, through its General Assembly, the power to create in its uniform taxation, the ability to create create categories of taxation that do not include the categories of shelter or non-functional property, non-operational property?
Like, I'm trying to understand your question, but I think you're saying, does Article 10 of the Indiana Constitution not give the
Yes.
authority to tax private non-operating property? Is that what you're saying?
Can the General Assembly create a category that has certain categories, but not the two that you seem to have been listing today, shelter and non-operational property? Could they have created
Yeah.
it otherwise and still fall within the purview of the Article 10, Section 1?
Yeah, the General Assembly doesn't have the authority to tax private non-operating property, and they pretty much lay it out. I mean, it's you just have to have the understanding.
Okay,
And then your previous question, I want to make sure I answer correctly. What was your previous question?
sure. Is it part of your position that the state of Indiana does not have sovereign power to tax the property in its state, at least with respect to your property?
With respect to, yeah, because that's with respect to my property. So my properties are private non-operating. They're just shelters.
Okay,
They do not have the sovereign authority to do that. And that's a misconception. So the state of Indiana, the government has the sovereign authority over entities. Okay. So you've got qualified immunity over corporations, like legal entities, like whoever, a creature of the state, you've got authority over them. You do not have qualified immunity over the people. Okay. And men and women in their private capacity, living their lives, doing nothing else, just going to their home and eating, sleeping, and whatever. They don't have authority over that.
okay.
It
Finally,
was never given to them.
Ms. Osborne, I'm looking at a document called Sales Disclosure Form. It's with respect to your property. Do you have that
Yeah.
available?
Yeah.
Okay,
Yeah.
I'm looking at page 2 of that, section D. Question number 3, planned use of the property described, and it says second home. Is that what your version says? Okay,
Yeah, that's fine.
what does that mean for you?
It means it's my private shelter.
Home, does that mean residential property? Does home mean residential property?
No.
Okay,
You can have a dwelling, a private dwelling on residential property. You can have that. That's why they have the homestead deduction. But no, private homes that are not doing any interstate commerce are not residential. That's the common misconception.
Okay, well, we didn't,
It's on.
it doesn't matter.
conversion.
We do not have the authority to make that declaration. So, do you, as the county, do you have any further thoughts?
No.
Any further thoughts here on the board?
I want to review my notes here for just a moment, Tammy, to make sure that I don't miss anything.
Sure.
Any questions? Madam Chairman, based upon the bountiful evidence presented, I wish to make a motion to say that this board does not have the legal authority to waive the property tax valuation on residential property as per Indiana Constitution and state statutes. Therefore, my motion is to deny the claim to vacate the assessment.
I'll second that. There's been a motion and a second to deny this claim to vacate her assessment and taxation due to lack of authority. Is there any further discussion?
No.
Hearing none. All in favor signify by saying aye.
Aye.
Aye. Opposed? Motion carries.
all right, Tammy,
Yes.
so that's